Well, good morning, and thank you to the conference organizers for creating this space for me to talk to you today about queer myths 50 years after 1969. I'm very honored to be on a panel with both Nick and Patrizia, who have been addressing some of the gaps that were created by these queer myths. So what do I mean by queer mythologies of 1969? Well, there's a dominant narrative that says the decriminalization of homosexuality set queer history on a progressive path to equality. Forgotten in this narrative is that no laws were repealed in 1969 and queer sex remained defined as a criminal offense. The reforms only applied to buggery and gross indecency and only allowed these crimes in the bedrooms of the nation. Criminalization drastically expanded after 1969, including for gross indecency, but also the other laws that remained untouched, including the Bawdy House law that was used in police raids on gay bathhouses, indecent acts, obscenity, vagrancy, and other 19th century statutes that form a web of criminalization. These get erased by the 1969 as equality theme, and yet in 2019 the mythology was firmly in place and was celebrated. We see this theme of 1969 as equality stamped on the special edition coins released by the Canadian Mint. Countering this narrative are these forgotten histories, like police violence, the bathhouse raids, raids on bars, entrapment in parks and washrooms, carding, and the bullying, harassment, and intimidation of lesbians, trans people, and Black, Indigenous, and people of color. In 2019, I published a response to these myths in the Canadian Historical Review. I took up this question of recriminalization, published by the Body Politic after the 1981 Toronto bathhouse raids. This editorial highlighted long-held community skepticism over the legacy of the 1969 reforms. There's a network of scholars and activists who have published on this topic. I encourage you to check out the Anti-69 website for more on these perspectives. These include the ableist contours of the 69 reform, the relation of the reform to the white paper, which proposed the destruction of Indigenous sovereignty and treaty rights, and the ways in which these celebrations of 1969 are further embedding a white imagination of queer history, excluding the stories of Black, Indigenous, and people of color. In another panel at this conference yesterday, the myths of the 1969 reform around reproductive justice are being questioned. In this presentation today, I'm looking at the role of queer organizations in spreading mythologies of 1969. In 2019, the Department of Canadian Heritage granted more than $2 million to celebrate decriminalization. I'm going to be talking about two of these grants. The first is Egal Canada, and a $770,000 grant called Legalizing Love, The Road to 1969. This grant was announced on the same day as the Prime Minister's apology to 2S LGBTQ people in November 2017. Bill C-66, the criminal record expungement legislation, was also introduced that day. C-66 was a flawed bill that only became law because of Egal's support. The second grant is Pride Toronto. They received $250,000 to celebrate decriminalization. But this was tied to a Grants for Police deal, in which Pride would receive grant funding to celebrate 1969, provided they invited the police to participate in the parade. Even before the Prime Minister's apology, historian Stephen Maynard identified Egal Canada as no longer representing the voice of the community. It's the government's agenda that's being advanced, with Egal positioned in the role of collaborator. I'm also inspired by Maynard's application of homonationalism and forgetting. Bill C-66 was a flawed bill. It was designed to expunge all police records related to historically unjust convictions for queer people. Expungement would destroy all historical state records, and this was a problem identified by historians and community archives. Another issue is that only two offenses were covered, gross indecency and buggery, which happened to be the two offenses that were reformed in 1969. all of the other offenses, including the Body House Law, were left out. If that wasn't bad enough, the bill also established an unequal age of consent, setting the minimum age of 16, even though the historical age of consent was 14 for heterosexual sex. The bill also placed a heavy burden on applicants. Those seeking expungement had to go to great lengths in order to track down their court records. As historians, we know how difficult this can be. I joined with Gary Kinsman, Patrizia Gentile, and Stephen Maynard in challenging Bill C-66. We published a briefing document raising all of our concerns. We also joined a broader network of activists and community groups demanding changes to Bill C-66, including the Canadian HIV/AIDS Legal Network and Sex Professionals of Canada. In April 2018, 8 of us demanding changes to Bill C-66 appeared before the Senate Human Rights Committee.
The apology will be flawed in major ways if Bill C-66 is not fixed. You have the historic opportunity here within the Senate and within this committee to actually fix this bill.
As my friends to my right have said, it needs to be broadened to include a number of other offenses.
The bill should, at a minimum, be amended to allow expungement in all cases where the sexual activity would have been lawful but for the party's sexual orientation or gender identity.
The fact is that without addressing the difference in the age of consent at the time of the offense, the bill perpetuates the very stigma and discrimination it is meant to address.
Nous sommes d'accord avec les propositions nous en venons aux mêmes conclusions là, que les Canadiennes lesbiennes and Gay Archive. Les recommandations qui mentionnent d'amender les articles 17 et 19 afin de prévenir la destruction des documents d'archives.
The committee should be aware that for Montreal in particular, it is the Body House laws that were the cause of the charges that were faced by most men in the past 40 years.
Like Ross Higgins, I was there to stress the importance of including those who were charged under the Body House Law. In preparation for this appearance, I created a chart that demonstrated that bathhouse raids wasn't just one incident. It was part of a much broader campaign of recriminalization after 1969. We were joined by Ron Roseness, one of the men convicted in the 1981 Toronto bathhouse raids. Ron and I went to police headquarters together and made an access to information request. We were able to obtain his record of arrest, and we used this to demonstrate to the Human Rights Committee that those who were convicted in the bath raids deserve to be included in the bill. Now I invite senators to view the chart I've provided on bathhouse raids in Canada. I've provided a copy. These occurred from 1968 to 2004 in the so-called era of decriminalization. More than 1,200 men have been charged under the Body House Law.
That I'm here to seek inclusion in Bill C-66. And it's, I think, perhaps a cliche, but it is the right thing to do.
Egal, however, took a different perspective on Bill C-66.
As Voltaire said, the perfect is the enemy of good. We support of the passage of Bill C-66. Pour conclure, nous soutenons le projet de loi C-66 tel qu'il est rédigé présentement et souhaitons son adoption dans les délais les plus brefs.
And so with Egal's sole support, the Senate passed the bill and it became law. No changes were made. A few weeks later, Egal presented Prime Minister Justin Trudeau with a leadership award. Meanwhile, Ron Roseness and I went down to the courtroom in Scarborough where he was convicted in the bath raids, and we obtained his record of conviction. We then applied for an expungement, and the response that we received was that he didn't qualify because body house charges are not included in the legislation. When we look at the $770,000 grant for Egal, we can see why they supported this bill as is. They don't even use the term decriminalization to refer to 1969. They use full-out legalization. EGAL later renamed this project to Sex, Sin, and 69, but the damage to our efforts on C66 had already been done. As of last month, only 9 expungements have been granted. The Ministry of Public Safety had previously identified over 9,000 possible cases. Both the government and EGAL must apologize for the failure of the expungement bill. The second grant I'm going to talk about today is a $250,000 grant to Pride Toronto. Formed in the midst of battles over police violence and the bathhouse raids, Pride Toronto was founded in June 1981 as a protest against continued criminalization after 1969. In 2016, Black Lives Matter reminded Toronto Pride of this history and called attention to anti-Black racism within the organization. Since this protest, police have not been included in the Toronto Pride Parade, despite the financial influence of state and corporate sponsors. The $250,000 grant has been kept a mystery. This is why I filed an Access to Information request. This request produced 796 pages of documents. 346 of those pages are entirely redacted, citing cabinet confidences. So why such secrecy over a 1969 heritage grant? Well, the reason for the secrecy is that this was not initiated by the Department of Canadian Heritage, as would be usual, but rather it was initiated by the Ministry of Finance. In September 2018, Minister of Finance Bill Morneau met with Pride Executive Director Olivia Noema to discuss the issue of funding for Pride. At a Pride board meeting a few weeks later in October 2018, it was declared that if Pride were to release a statement about police participation in the parade, it would facilitate funding from government sources. Pride released their statement inviting police back into the parade, making good on their deal with Bill Morneau. As a result, on November 2nd, the Department of Finance transferred $250,000 to Canadian Heritage to cover the costs of Pride's grant. Even though the grant was bought and paid for, Pride still had to apply for the funding. A few days later, on November 7th, Pride submitted their grant application to Canadian Heritage. The link to police is clear. Pride says that they are particularly targeting police services in celebration. They also talk about an opening gala commemorating 50 years of decriminalization. They mention the creation of a national council made of members of the Association of Police Chiefs. And in justifying this grant, Pride Toronto declares that Canada was the first country in the first world to decriminalize homosexuality and marks a significant period in Canada's history when it took a step through which the rest of the developed world followed. This statement is a complete fabrication. Even if one were to believe the 1969 decriminalization myth, it was modeled after the British, who adopted their reforms in 1967, 2 years earlier. Other nations had passed their reforms in the years and decades prior to that. It's clear that Heritage didn't have the time to properly vet this application, and since they weren't paying for it, who cares if Pride makes this bogus claim about Canada being the first? On November 24th, Bill Morneau announced the 1969 grant. Joining this was the Ministry of Public Safety. Because of the involvement of police, they contributed an additional $200,000, bringing the total grant to $450,000. The invitation to include police into Pride was met with a great deal of community resistance. At the end of January 2019, the membership of Pride Toronto revolted and voted against Pride's decision to invite police back. Among those protests was the resignation by one of the Pride Board co-chairs, Aaron Edgell. In Edgell's resignation, they state that fiduciary responsibilities required them to put the well-being and survival of the organization first, and that if they didn't, they were told the consequences would be severe. The Pride Board thought they had no choice but to include the police, and they were held hostage by this grant. This revolt was noticed by members of the Department of Canadian Heritage. They scheduled a call with Pride to discuss the impact of the changes and pressures within the organization and how that might affect the grant. By May 2019, the month before Pride, the project looked completely different from their original grant application. In their interim report submitted to Heritage, Pride declared that they had fully executed a contract with noted Cree artist Kent Monkman. As part of this update, they attached a poster for a Kent Monkman exhibit totally unrelated to decriminalization or 1969. Kent Monkman has never created an exhibit to celebrate 1969 or an exhibit related to decriminalization. As a result of this project update invoking Kent Monkman, Pride received its second check from Heritage for $104,000. There was no contract with Kent Monkman. This is reflected in an email update a few months after Pride, in September 2019. Heritage officials were informed the project has a new hire and that they're building something altogether new. This was the last project update in the Access to Information documents. On February 3rd, 2020, Heritage officials noted that Olivia Nuema was no longer executive director of Pride Toronto. It was also at that point that I filed the Access to Information request. It took over a year to get these documents released, and with so much redacted, I still don't know the full story of what occurred to that $450,000. I just want to finish with some concluding thoughts. First, Pride Toronto must address the secrecy behind the Morneau Pride 1969 Grant for Police deal. I sent the Pride Board a letter over a year ago outlining my concerns. This went ignored. I attended 2 AGMs asking questions about these grants, and yet they're still shrouded in mystery. This grant has revealed that Pride does not work in the corporate form that it has adopted, in which it's always expanding, running huge budgets, requiring major corporate and government sponsors. I just don't think it works. Instead, Pride should disband and return to its community roots and take a stand against police violence, no matter what grants are offered. C66 became law because the government had one queer group supporting the bill without amendment, Egal Canada. Egal needs to be known as the leading queer organization advancing the government's agenda. They have abandoned any community roots. Stephen Maynard's assessment of Egal has been confirmed, and Heritage grants have played a key role in developing this collaboration. With only 9 expungements granted, this legislation is a disgrace and a betrayal of the 2017 apology. Finally, there's no place for the state in the Pride organizations of the nation. The Department of Canadian Heritage should not be pushing queer mythologies. This grant for police deal should never have been created. The government must immediately release all of its files related to this deal. Thank you for listening to my presentation. I look forward to your questions and comments, and I look forward to the rest of the conference.